Court is now in session with your host, Peter Briggs.
Welcome to the Lawyers to Lay People podcast, a conversation-based podcast featuring interviews with some of Georgia's top lawyers, where we, in an easy-to-understand, non-lawyerly way, answer the questions that are on the minds of you, the layperson. In this podcast, we talk to specialists in a particular field of law to hear directly from them as to what clients typically ask them and what they should be asking. I'm your host, Peter Bricks. A little about me. I'm a personal injury and bankruptcy attorney, as well as a registered mediator currently practicing in Atlanta, Georgia. I graduated law school in 2006 from Georgia State University, and I've been practicing as a lawyer here for almost 17 years. My guest today is Jonathan Ginsberg. Jonathan is a Social Security disability attorney who represents men and women who can no longer work and who are seeking disability benefits from Social Security. He's an attorney at Ginsberg Law Offices in Atlanta, Georgia. Most of us know that Social Security pays older retired workers a monthly benefit based on taxes collected over a lifetime of work. But Social Security also pays disabled workers a monthly benefit no matter how old you are. But there's a catch. Unlike Social Security retirement, which is paid automatically at retirement age, disability benefits are paid only if you can prove to SSA that you meet the very strict definition of disability. Most disability applicants are denied when they first apply, and attorneys like Jonathan help deserving disability claimants win their cases. Today, we're going to learn what it takes to win disability benefits from Social Security and what type of cases have the highest probability for success. Jonathan also has a website called SSDAnswers.com, where you can get a free Social Security disability case evaluation, as well as a free survival kit with secrets of being approved. Jonathan also publishes the largest and most active Social Security disability YouTube channel in the United States with almost 400 videos, 63,000 subscribers, and over 7.6 million views. All right, Jonathan, welcome to the podcast.
Thank you very much. Good to be here.
All right, so why don't you start off telling us how long you've been practicing SSDI and what you like about it?
Well, I've been doing this for about 32 years now, and it's a very interesting area in that every day something's different. I'm learning about a lot of different medical issues. It's not the same thing every day. There's a lot of hearing work. It's not heavy-duty trial work, so it's fairly low-key. And basically, I'm helping people who really can't do this on their own. Social Security makes things very, very difficult. It's a very confusing process. There's a lot of acronyms they use, and it's very easy to get lost. And so when I'm able to take a case that I think has potential, develop it properly, present it to a judge, and get a person an award, basically they're going to get monthly benefits, it really makes a difference in their life, because these are people who can't work and have no money coming in, and after waiting a really long time, if we get the good results, then they'll get money coming in, and it really makes their life a lot better. So it's very rewarding in that regard.
All right, you mentioned take a case.
Yep.
So my first question is, even before we talk about retaining a lawyer, whether the person's just handling on their own, how do they know if they actually have a case that is likely to succeed?
Well, remember, the definition of disability is, does a person have a medically determinable impairment, which is really like a diagnosis, that has lasted or is expected to last 12 consecutive months, so it can't be a short-term thing, that prevents that person from engaging in what they call substantial gainful activity, or another way to look at this would be, can they work? So the real issue in a disability case is not the medical. People get very confused. They think, well, I've got a herniated disc, I've got congestive heart failure. That does not make you disabled. What makes you disabled are the symptoms or medication side effects that impact that person from working. So the main thing I would say is, when somebody's thinking about filing for disability, how does their medical problem prevent them from working, and can they do even a simple entry-level job? That is the core issue in a disability case. Can you do a simple entry-level job?
So let's say it is impacting their workability. When in the process of the impact has started, should they start the claim? Do they need to wait a few months?
No, as soon as they stop working. You cannot file when you're still working, because, again, they define disability as the inability to work. So if you're still working, you cannot pursue disability. So people sometimes think, well, I'm really having a hard time at work. Can I start the process now? No. You have to stop working or have to be in a position where you're likely not going to be not going to be able to go back for at least a year. And then that's, at that point, what I would do is look at the medical. Is it sufficient to support them? Because they've got to have ongoing medical treatment. You can't simply stop working and say, I'm disabled, I want to go ahead and start the process. You've got to have medical support for it. So it's really about work capacity, but being supported by medical evidence.
So let's say now you're going to go forward with that application.
Yep.
What is your opinion about whether an attorney should be involved in the initial application process?
I don't think it's absolutely necessary. I mean, I think if someone is reasonably intelligent, they do their homework, they can file an application. You can do it online, ssa.gov/apply for disability. It's about 60 questions. I will say practically it can be very difficult to fill this form out using a cell phone, a smartphone, because it's a lot of questions, very small. Much better to do it on a laptop or a computer where you can see it. People get really freaked out by all these questions, and some of the questions they ask, they don't really give you instructions about how to answer it. In fact, I wrote a book about all this called Disability Answer Guide, where I go through all the questions that are being asked and how to answer them. But I think generally speaking, most of these questions are biographical. They're going to want to know the doctors you've been to. They're going to want to know your past. They ask a lot of crazy questions about your past marriages and previous marriages and all this stuff. But if you have this basic biographical information there, you can do it. You can also stop and come back to it. So you can start an application and come back to it. So I would say about half the people I represent, I do the initial applications, but it's not absolutely necessary. Some people just don't want to mess with it. Realize if somebody is pursuing disability, they may be in a lot of pain. They may have difficulty with concentration and focus. They just want me to do it. So I'll do it, but it's not absolutely necessary.
Now, how are fees different for helping with an initial application versus, I guess, if you get an award,
right, going on,
you get it a statutory amount. How is that different?
Yeah, basically the fees, there's a couple ways to get paid, but 99% of the time we are paid 25% of accrued or past due benefits with a maximum of $7,200. And that fee cap changes periodically, but now it's $7,200. So whether I get involved at the very beginning or whether I get involved the week before the hearing, my fee is 25% of benefits that have accrued while the person's waiting for Social Security to make a decision. They don't pay you the first 5 months. So if somebody files an application and they get approved right away, and they've just, let's say they had a horrible car accident or some sort of a major trauma, they file and they get approved in 2 months, there may not be any past due benefits. So I've got cases where I've filed an application for somebody and I don't get paid at all. Doesn't happen often, but that's sort of that's something I do. If somebody really needs to be, needs their application done, I'll sometimes do it for them. But most people, because of the long delays in the system, there'll be some past due benefits.
So let's say the clients handle the initial process on their own and they've been denied.
Yep.
And now they need to reach out to an attorney.
Okay.
How quickly after the denial should they reach out to you, and are there ramifications if they wait too long?
Yep. Once you get a denial, you have 60 days to file an appeal at the initial application. The first appeal is called a request for reconsideration. This, again, is done at administrative level by the Social Security Administration. You do not have to have an attorney to do that. Again, most people, I'd say a decent percentage of people that hire me do so to file their first appeal, the reconsideration appeal. It needs to be done within 60 days. So I would say if you get a denial, reach out to an attorney pretty quickly. You don't want to wait on that because there's just no reason to wait. And 60 days will go by very quickly. And it's very hard when somebody calls me and they're at day 58, to get all the paperwork done and get it all ready. I can do it. And also I will tell you that occasionally somebody will miss the deadline, and as long as we're within 3, 4, 5 months, I can probably get them. I can probably go and show good cause to get that undone, so that I can get them filed anyway. But that's a sort of a separate procedure. But I would say, big picture, if you get a denial, call an attorney quickly.
And if you were outside that 60 days, is the real issue that if you eventually succeed, you're behind as far as how many past months you can claim?
Well, if you miss the deadline, then and you ask for good cause to have it reopened, so you keep your case going. Otherwise, you have to start over again. So that starts the clock over again. And one of the things that we'll talk about, I'm sure, is the delays. Social Security right now, terribly understaffed, fewer people than they had 20 years ago. The average case is taking anywhere from 18 to 30 months from the time they file to the time they get a decision. So the first stage of it is about 9 months. So if somebody files an application, it's going to probably take about 9 months before they get that denial or an approval. If they don't file an appeal on time, they got to start over again. So now you've got to wait another 9 months to get to that point where you can file an appeal. So it really, it causes a lot of financial hardship to miss the deadline.
So you sit down with the client, the initial interview. What are some of the common questions they ask you, and what are some of the things maybe they just don't think about that they really should be thinking about?
The first question they ask is, how long is this going to take, which is, obviously a big issue. The second thing is, what are my chances of winning? They're going to want to know what they have to do. A lot of people want to know, can I try to work? And the answer to that is yes, you can try to work. You have to be careful, though, because Social Security has very strict limits. If you're earning more than a certain amount of money, called substantial gainful activity, which in 2023 is $1,470 a month. If you're earning more than $1,470, then you're considered to be working. But there's special rules if you go over for a month or two, but you're working part-time and you're earning $1,000, $1,200, then you have 1 or 2 months where you're at $1,800, that won't necessarily hurt you. So it gets a little tricky there. But I will tell somebody, if you're going to try to work, let me know, and let's keep very close track of your gross earnings to make sure that you don't work too much to take you out of the disability world, but not make enough to make it worthwhile to continue working. It's a very tough balance sometimes. But I get those questions a lot, because if you think about it, if somebody's applying for disability and they are waiting for 2.5, 3 years, what are they supposed to eat? This is a real problem, and so people will want to go back to work, and so I'll give them some guidance on that as to what they can do.
So how long is it typically from, assuming you get a case right after the denial, filed your appeal, how long is it typically until you get a hearing?
Well, again, the first appeal is called a reconsideration. It goes back to the Social Security Administration, somebody called an adjudicator. And the adjudicator is like an insurance claims adjuster. They're not a judge. They're simply an employee of Social Security who is going to look at the file and consult with an in-house doctor. So the first stage, somebody applies, the first initial evaluation is about 7 to 9 months. Typically, it can be less, but it's usually 7 to 9 months. If they get denied, they file an appeal, it's going to be another 7 to 9 months. So right there, we're already going to be at a year or longer. We then filed the second appeal, which is a request for a hearing. That may be in 5 or 7 months before we get to a hearing. So you don't get to a judge right off. You first file an application. It goes to the Social Security adjudicator. You get denied. You appeal. It goes back to another adjudicator. Then after that adjudicator, that's when you ask for a hearing before a judge.
So the attorney-client relationship during that 1-2 year period, what all are you doing for the client other than, say, following their medical treatment? Yep. How does that work? Okay. Well,
basically, we are obviously gathering medical information, and we submit that. Also, Social Security sends out just an innumerable number of forms, activities of daily living, pain questionnaires, work efforts, just all kind of forms. I can't even think, there's just dozens and dozens of them. So they get these forms, and so I've created a library of screen capture videos where I explain how to answer the forms, and I will tell my clients, when you get a form, fill it out as best you can, because it's got to be from them. Send it to me. Let me look at it. Let me give you my feedback, and then we'll submit it for you. So that's a lot of the stuff that we're doing is making sure those forms are being submitted. Social Security will send people out for what are called consultative evaluations with one of their doctors. So somebody gets one of their doctors, they get a notice of a consultative evaluation. I'll get an email. What do I expect from this? So I've got videos about that, but sometimes they want a phone call. What do I expect? What should I say? I think a lot of it is just gathering the medical information, keeping that up to date. If they go to a new doctor, what I will typically do is I will contact Social Security on their behalf. This person has now gone to Dr. So-and-so. He's gone to an orthopedist. She's gone to a neurologist. Please get these records. And then I can log into their account to see, has Social Security requested those records. I also have electronic access to their folder at Social Security, so I can see what's going on. So if I see nothing happening in 4, 5, 6 months, or even 2 or 3 months, I'll pick up the phone, call Social Security, the adjudicator, what's going on? Why is nothing happening? Move things along a little bit. And again, clients will just call with different questions. A lot of it's about work attempts, or I've moved, I can't afford to live where I'm living, I moved, can you do some sort of a dire need type of thing, which occasionally we can. Things like that. So it's just kind of a maintenance thing. I mean, I'm not going to tell you that every day I'm working on every single case, because I'm not, but there are problems that arise during that 2-3 years that we have to deal with, and that's what we're there to do.
So I want to talk about the hearing in a second, but before that, what just general percentage-wise, can you ballpark how many people are able to get benefits at either the initial application or this reconsideration period, so that they don't even have to do the hearing?
So at initial, there's something out there called a waterfall chart that Social Security keeps track of, approvals. At the initial application level, about 35% of claims are approved. So about a third of people who apply are approved. Most of those are people with really, really serious illness. Let's say somebody has a metastasized cancer. That would be grounds for an early approval. They've had an amputated leg. They've got, they're blind because of diabetes. That's the level of impairment. It's called listing level. We can talk about the different theories of disability, but the listings are one of the main areas. So for early approvals. So if somebody is really, really sick, that's when they're going to get approved early on. So about 35% of applications are approved. The other 65% are denied. Of the people that appeal, not everybody appeals, but of the people that appeal and file for reconsideration, about 10 to 15% of those are approved at reconsideration, a very low percentage. Reconsideration, in my mind, is a waste of time. It's basically a delay tactic where Social Security uses it to weed out people, to discourage people from continuing on, and it just keeps the money in their account longer. So it's kind of a waste of time. I would say in 30-something years of doing this, I've probably had maybe 10 cases approved at reconsideration. It's just very, very rare. When you get to a hearing, nationally it's about 50%, 50% of cases at a hearing are ultimately approved. Those with an attorney, it's closer to 80%. And that's partially because attorneys are going to only choose cases that are viable, because that's how we get paid, obviously. But statistically, the best chance of getting approved is at a hearing.
All right, so you mentioned that 80% having viable cases. What is the key to a viable case, a winning case at a hearing? How do you prep your client? How does that work?
I think there's several factors that are really important. Believe it or not, one of the big ones is age, because Social Security has a real bias in favor of people at age 50 and over, especially those at 55. So if you are 55 and over with a diagnosed medical condition that has functional issues, there's a good chance you're going to win. So one of the major factors I look at is their age. I look at work history. Do they have a consistent work history? Judges tend to find people very credible if they've worked consistently over a long period of time, 20, 30 years, because if you think about it, someone who's 58 years old, who's worked 30 or 40 years, whether it's in a warehouse or in an office, they're not going to stop working to sit at home for 2 years hoping Social Security is going to pay them. So a long work history is a big deal. You need to have something that's diagnosed, ideally something that can be imaged with an MRI or a CT or a pulmonary function test or an ultrasound. Much more difficult to win cases where there's no image on it. For example, fibromyalgia cases, very difficult. Depression, anxiety, very difficult because you cannot take a picture of it. So I'm looking for cases that can be imaged for the most part. I'm looking for a level of severity. It's got to be something pretty serious. A back injury, a mildly bulging disc is one thing, but a significant herniation with nerve root impingement is a much stronger case. I'm looking for treatment with specialists, ideally, as opposed to a family doctor. So if somebody has an orthopedic issue, I want to see treatment with an orthopedist or a neurosurgeon. Ideally, they're a surgical candidate or they're in pain management, something like that. So that's sort of what I look for, is just a level of severity, a credibility factor in terms of their work history, and, of course, their age being the big ones.
So you mentioned a lot of stuff about orthopedics and imaging and all that. How is medical testimony actually presented to the judge at the hearing?
Very relaxed. Social Security is an administrative proceeding. It's not judicial. So the hearings are done by an office of the executive branch. In fact, most hearing offices, physically, if you went to a hearing office, they're in an office building. For example, the one downtown Atlanta is in Peachtree Center office tower. There's another one out in Alpharetta in an office complex. So they're very informal. We submit evidence, copies of medical records. There's no chain of custody certification. It's basically we just submit them. Judges are just going to look at the medical evidence. It's all done in writing. I would say a tiny percent, maybe 1%, less than 1% of cases would you actually have live testimony from a doctor. It's almost always, there's no deposition testimony. It's pretty much only going to be medical records that are in written form.
Now, that hearing, how much is your client actually testifying? I imagine they're kind of nervous. Mm-hmm. How does that work as far as preparation and what's the most important thing they need to keep in mind when they go testify?
Yeah. Well, the hearings last about 45 minutes to an hour, so they're not very long. They're pretty relaxed, and mostly what happens is the judge will ask them about their past work, so we always go over that so they have that clear. And then really the most important thing somebody can do is talk about how their medical problems impact their functioning, whether it's activities of daily living or their past work performance. And I always tell my clients, you want to be very specific. People, when they get nervous, will kind of, fall back into, I can't sit very long, I can't stand very much, I can't walk very far. Well, that doesn't tell us anything. So I'll tell somebody, we'll practice this. How long can you sit? I can sit for 15 minutes. Then I get so uncomfortable, I've got to stand up and walk around for 7 or 8 minutes. Oh, but I can't just stand there. I've got to actually physically walk around and move to stretch out. I have to lie down for 90 minutes because of pain and fatigue at least 3 days a week. You want to be very, very specific. So a lot of what I talk to my clients about is being very specific. There are other questions I know they're going to get asked about their work history, so we make sure that they can testify. And I'll tell them, have it in writing in front of you. What did you do? When did you work there? What was your job position? How much did you lift at that job? Was it a standing, walking job? Were you exposed to fumes or pulmonary irritants? Just to give them specifics so they can remember. A lot of times, when you look at the work history from Social Security, it'll say, doctors medical advocate number 3. It's a Wendy's restaurant, but it's a corporation that owns it. So they won't recognize the official name of the employer. So we have to make sure we match that up, so they have a good idea and they know what their jobs were. So that's a big part of it as well. Just being comfortable answering questions. I probably spend more time in my pre-hearing than the client spends actually at the hearing.
So you've touched on the length of this whole process, mm-hmm. which is pretty lengthy.
Yep.
And you've touched on this, but this is kind of an obvious question. How in the world do these clients keep themselves financially stable during this 2-year, 3-year wait potentially?
It's a real problem. And Social Security is a mess. At times in my career, the process would be a year or less than a year. Now it's 2 years or longer. I tell my clients, in fact, when I talk to somebody who's sort of working but hanging on, I'll say, look, hang on as long as you can, because this is a long process. You may get an unreasonable judge, and it could all be for naught. But I would say, arrange with relatives and friends if you have to, stay with friends and relatives and get help. Obviously, if you've got a spouse who's working, that can make a difference. But there's no good answer to that question. There is really no great answer because there's no presumptive benefits. Some people have, they may be getting VA benefits so that you can double dip with something like that, or long-term disability. They can get that. But if they don't have any of that, it's just however you can manage it. It's a real problem.
And if your client does succeed and get their claim approved,
yep.
Is that claim at all based on their earning history? How is the amount
yep.
that they receive? factored?
Generally speaking, I mean, there are two types of disability. I deal mostly with SSDI or Title II disability. That is a function of what they've paid in. If somebody wants to go to ssa.gov/myaccount, they can download their My Social Security statement. It will show them how much they're going to get. But generally speaking, in a disability case, they're going to get an amount that is roughly equal to their full retirement amount. So if you know your full retirement amount is going to be $2,300 a month, that's what you'll get from disability. So that's the amount. SSI, which is sort of a means-tested program or more of a welfare type of program, that is for people who don't have enough earnings credits to qualify for disability. That's set by statute. I think it's less than $1,000 a month, so $900 and something a month, I believe, in 2023. But it's subject to a lot of offsets. So, for example, if somebody is married and their spouse works and makes any reasonable sum of money, they apply for SSI. The spouse's income is deemed, they call it the deeming rules, is deemed to them. It reduces their SSI. If they're getting support, room and board from a family member, that reduces their SSI. So SSI is really for people who have nothing, who have no any type of support at all, and it's just there's not a lot of money in it, quite frankly. So it's a real poverty type of program. It's just not a great program. They haven't changed the numbers in years, and I don't really know how people are expected to live on $800 a month, $900 a month. But to answer your question, SSDI is a function of what they've paid in. So if you've been earning $100,000 a year or more, your benefits amount's going to be, $2,500, $3,000 a month. If you've earned, at $25,000, $30,000, your benefit amount may be $900 a month. It really is a function of what you paid in.
So basically, you could have someone with a winnable case on the merits,
Yep.
but you just can't take it.
Can't take it because they're right. I mean, I don't take a lot of SSI cases because, if the person's married, for example, there's not going to be any benefits. It's going to be offset. And so, yes, there are cases that I'll come across my desk that I think are winning cases medically, but because of the likelihood of offsets, there'll be no money in it, and I only get paid if I win. So I can't take those cases because I've got to stay in business. And again, the amount of money the attorneys get, I'm not complaining. This is what I choose to do. But this is not something where there's going to be in a personal injury case or a workers' comp case, you may see a recovery of $150,000, $200,000. The fee could be $20,000, $30,000. It doesn't work that way in Social Security. It's much more limited. So I've got to be very careful because if I'm taking a case for 2 years, I'm paying my staff. So it's got to be something that's viable.
So assuming your client wins on the appeal,
Yep.
How long typically is it till they actually get paid some money?
About 2 months. So if we win, it goes through the payment process. Normally it takes about 2 months before they see any money.
Well, first off, how long till they find out that they've won after the hearing?
I'd say anywhere from 4 to 8 to 12 weeks. It just depends on, and the way Social Security does it is the judge will hear the case, make a decision, send it to a decision writer who is not there in a different state half the time, and they, depending on how backlogged they are, that could take 2 or 3 months. Usually, most judges try to get it out pretty quickly, so I would say on average it's 4 to 6 weeks to get a decision, then another month or so after that before the money comes.
And that money would be a lump sum for the past, plus
Correct.
Now they're starting to get these
Correct.
ongoing monthly.
Correct. And attorney's fees are only on the past due, not the future benefits.
Okay. So let's say there's your client's been approved, and are you uninvolved at that point? Or, I guess first off, let's take the scenario where you've got a client who is likely to continue to be disabled. Do they have to do a renewal every 6 months, let's say? How does that work, and what would the attorney's involvement be in the renewal process?
Okay. So there's no renewal, but basically the judge will typically put on the decision that this person is to be reviewed in 1 year, 3 years, or 5 years, or maybe 7 years. I think it's 1, 5, and 7, or 3, 5, and 7. But bottom line is if it's a 3-year review, and some judges will put 1 year, then Social Security will send them a questionnaire to make sure that they are still disabled. A 1-year review would be a case where the judge feels like, okay, the person has a back injury, they're scheduled for surgery, they're likely to improve. In that situation, they're going to be reviewed, and they'll be asked to document what their situation is. they call these continuing disability reviews. And so generally speaking, the older the person is, the less likely they're going to have a review, because the closer they get to retirement age, less likely to need a review. But let's say someone who's 45 years old is approved, they may get a review in 3-4 years. And at that point, they have to fill out a bunch of forms and so forth. They can choose to have benefit, and if they fill out the forms and Social Security decides they're still disabled, no problem. But if Social Security decides that they're no longer disabled, they're moved to terminate. In that situation, the person can choose to have benefits continue while they appeal. The problem there is then they can't hire an attorney because there's no past due benefits, or if they choose not to have benefits continue while they appeal, meaning they have no money to eat, they can then hire an attorney in a contingency. So it is a real problem. So somebody who is reviewed, if somebody has a review questionnaire and they call me, I may look at that. If they want to hire me to do it just to help them to fill out that form, they can pay me on a on a contract basis. That is not part of the original representation. The representation ends at the time the case is decided. If they want to hire me to represent them in the continuing review, they can do so, but either that would be an out-of-pocket cash payment if they have benefits continue, or if the case is really strong and I say, okay, they're going to be past due benefits, then I may take it on a contingency.
So it sounds like this next one would also be outside the scope of your representation, but if the client decides to return to the workplace after they've been reviewed, approved, is that something that you ask them to reach out to you for some particular reason, or how does that work?
Yeah, not really. I mean, basically, once they're approved, I'm available to people if they have questions, quick questions. But again, if they need legal advice, I'll give them a discounted rate, but I'll charge them for my time on that. What they have to be very careful about, and I've actually put out some videos on this, is there's something called a trial work period in disability cases, where somebody can work and have unlimited earnings for up to 9 months in any 5-year period of time after they're approved without impacting their benefits. The goal there would be to get them back to work. So let's say somebody is approved for disability a year and a half from now. They just say, I'm going to take a job. They get a job making $10,000 a month. Doesn't affect their benefits. But once they hit 9 months out of doing that in any 5-year period of time, they go into overpay status. That can be a real issue because Social Security does not notify them in real time about how far along they are on their 5-month or their trial work period during that 5-year period of time. And so you have people sometimes that work a month here, work a month there, and then all of a sudden they get a notice saying you owe us $30,000 because 2 years ago you ran out of your trial work period months, and that can be a big problem. That's an overpay situation. I don't handle those. I typically refer those out. There are a couple of attorneys I know who do that. It's kind of a where you have to argue that they operated in good faith and it should be waived. It's a real mess. So I always tell people if you're going to work, be really, really careful about it, and you may want to call me just to give you some advice about how to track your trial work periods.
And so if they don't win with the judge, my first question is, are there any immediate type of benefits that they could become eligible for that they say, look, I was denied at SSDI, now I can qualify for XYZ?
No, I mean, there's no disability. I mean, there's some states have their own disability programs. I think California and New Jersey do. But if they're denied at Social Security, they can appeal that, by the way. They can appeal it to something called the Appeals Council. And if they're denied at the Appeals Council, it would go to federal court. Those will be reviewed. And in fact, I don't have time to do those. I refer those out to a colleague of mine who does nothing but Appeals Council and federal court work. And he's usually successful if he chooses a case. It'll come back to the judge. But now we're looking at, a 5 or 6 year window. But if they're denied at disability, then there's really not much they can do in terms of any programs I'm aware of. I mean, they can obviously pursue, food stamps or things like that, but there's no other program that they can do. They either have to go back to work or they can try again, and maybe something has changed that would give them a better shot next time.
And if you have been approved and you mentioned having a lot of older clients, what happens when you reach full retirement age and you're on SSDI?
Okay. So with Social Security, when they get approved for disability, they become eligible for Medicare 2 years from the date of first payment. So if somebody is approved, remember there's a 5-month waiting period, assuming that runs. So let's say their first payment was for March of 2021. In April of 2023, they become eligible for Medicare. So now they're on disability benefits and they're on Medicare. When they hit retirement age, they can stay on disability until full retirement, or actually to the extended retirement, and then they can start collecting their retirement Social Security. And if somebody is 62 and they've already chosen early retirement, they can pursue disability. They would then get the difference between early retirement and disability or full retirement, and they would be grandfathered in at the higher number. So I have some clients who are 62 and 63 and they file for disability. They're already getting Social Security retirement at the lower amount. If we win, then we're going to boost them up to the full retirement amount or the higher retirement amount.
All right, let's transition a little bit to now kind of talking to other lawyers. What would you say is the best way for, you mentioned you've been doing this for 30 years. I don't know how you broke into it, but what would be the best way for a young attorney who's interested in practicing Social Security law to get started?
I think that, one of the issues with getting started with this is there's a long lag in terms of getting paid. And as an attorney, obviously, you've got to keep the lights on. So realize if you take a case in at initial or reconsideration, it may be a year and a half before you see $1. So I think the first thing I would say is if you're going to get into this, you need to have another source of income, another source of practice while you're waiting for your caseload to build up. Because if you start on day one, you're not going to see any money for a good while. I think the second thing is to, learn as much as you can about this. I mean, I've got a very extensive YouTube channel. A lot of people look at that. I've gotten some really good feedback from other attorneys just by looking at my YouTube videos. I've got close to 400 of them now. So that's a lot of information. There's some good, resources out there. Actually, I teach a course at something called Solo Practice University, where I teach, new attorneys or newly solo attorneys how to kind of get into this. It's not hard. I mean, I'll be honest with you, this is not, a really difficult substantive area of practice. The issues are pretty straightforward. Can your client work or not? And the real key is case selection. It's also a little interesting because now that hearings are mostly done virtual, you're not limited geographically. So up until COVID, I was only taking cases in the Atlanta area because I'm here. And to drive to a hearing, 45 minutes an hour, I could do it. I'm taking cases in all over the country. So it does give attorneys who do this the option to, be very selective and take cases from really any state they want to. So that's a really good thing. Social Security can be really frustrating to deal with, but I'd say, do your research. I mean, there's some good blogs out there. There's some good books, how-to books, about how to get into this practice area. I would say try to find an attorney who does it, and, get a mentor. One of the things that disability hearings they do at the hearings is they record the hearings. So when I'm training other lawyers, I'll take with my client's permission, of course, I'll take some of these audio recordings of the hearings and let my client listen to it. And so this is not my client, let the other attorney listen to it so you can kind of see what's being done. Things like that. When the hearings are live, which there are very few live ones now, I would ask the judge, can I have somebody sit in with, on this? And they'll usually say yes. If it's a remote hearing, I'll ask the judge and they can listen in as well. So I think it's just a matter of getting used to all the details of it. Again, a lot of forms, and in my practice now, I've got, staff people who fill out the forms, but a new attorney would want to do that themselves. Here's how to, fill out the forms to get used to the whole notion of what it means to prove somebody's disabled and learn how to gather medical evidence. I mean, there's like anything else, there's an art to it and a science to it, but I think having a mentor, somebody who will work with you and answer those questions can be very, very helpful.
Now, you mentioned practicing in other jurisdictions since COVID. My first question is getting clients all over the country. Is that mainly just because of your large internet presence, or is there some other? No, I mean,
for me, it's I've got a large video presence. I've got a podcast. I've got websites out there. I speak a lot about this. I do a lot of CLEs. nationally. And so it's just a matter of getting out there and just, letting people know what you do. I answer questions on some of these social media sites like Quora or even Facebook, Avo. There's a number of different places you can answer questions to get yourself known, and then people will eventually find you. Obviously, having a website would be helpful. But to me, the bigger problem I've got is just weeding through, the leads, because a lot of people, think they're disabled, and I respect that, but they're not a winning case. I mean, I know, for example, mental health cases being very difficult. A person with a mild level of depression who's 38 years old is probably not going to win. So, it's just a matter of respectfully telling those folks I can't really help you and just going through that. So that's for me a time I have a person, that's what she does. It's just kind of responds to the leads. So I think you've got to be very, very selective, and don't let, if you're new, the temptation would be to take everything that walks in the door. You can't do that because you could waste a lot of time. Now, I'm going to talk about case selection a little bit more in a second, but back to the practicing in other jurisdictions. So since COVID, how many states or courts have you filed cases in outside Georgia? I'd probably say 30. I mean, I just filed one in North Dakota. I just took a client from North Dakota, the first one from North Dakota the other day. I have them in Hawaii. I've got a lot in California, Texas, Arizona, New York, New Jersey, places like that. It just depends. I mean, they're from all over. It's just a matter of finding, people that I think have good, viable cases, and I'll take them. I don't care where they are. And are there some potential issues with the judge, just always dealing with judges you're not familiar with potentially, or is there anything you've seen in that front? Yeah, not really. I mean, I think most judges do it the same way, and I think there's enough people who do national work. In fact, even a lot of attorneys who used to just do local stuff now advertise on their website they do nationally. I don't find a huge issue with any judges. I actually starting to know some of them because I'm seeing them over and over. And, out of Texas or California, I see enough of them where I'm starting to get to know them a little bit. That has not been an issue. I mean, I think if you know what you're doing, you present your case properly. I mean, judges, their interest is to make sure the record is complete, that all the medical records are there, that the attorney has a reasonable argument that and is not going to waste his or her time. I learned a long time ago, you probably have too, if you have nothing to say, don't say anything. You've probably seen attorneys who managed to pull defeat out of the jaws of victory. And, if everything is going well, keep your mouth shut. I had a hearing today right before we taped this, and the judge asked all the questions I was going to ask, and she said, "Do you have any questions?" I said, "No." I said, "You've asked all the questions I wanted to ask." I don't need to hear myself talk. So I think judges pick up if you know what you're doing, and you're not wasting their time. And if you keep your questioning focused on vocational issues as opposed to things that are not relevant to the issue at hand, which is the person's capacity for work. In regards to case selection and objective evidence, will you take a case that is just based off subjective complaints of pain, or are you pretty much you need to see something on an MRI before you're going to jump into a case? Yeah, I'm pretty selective at this point. Thank goodness I can be. So, I mean, there are cases like I'll give you an example. I have sort of my own mind like a checklist. So, for example, if I'm looking at a mental health case, depression, I'm looking for multiple inpatient hospitalizations at a psych hospital. I'm looking for suicide attempts. I'm looking for multiple failed medication trials, things like that. That's the level of impairment I've got to see. Somebody they've got depression, they're treating with a psychologist, and they've got to have ongoing treatment. If they're just treating with a psychologist, they're on medications, and they're fairly stable, probably not going to take that case because it's not a winner. I just know, and unfortunately, for example, I see a lot of people, I get a lot of inquiries from people who've been in the military who are claiming disability based on PTSD, and they're 100% VA, a permanent total disability by the VA. But if they don't have, that next level, the suicide attempts, the inpatient hospitalizations, really severe evidence of an impairment, a 38-year-old veteran with PTSD, 100% VA disabled, they just don't get approved. It's not fair. It's not right. They just don't get approved. So I just don't take those cases. I just know. I mean, you sort of get a sense of it. This is a case that is viable. If it's a back injury case, I'll have people send me MRIs. They'll say, well, I've got 4 MRIs. All the MRI says is they've got arthritis in their back and they've got mild, disc bulge. that's just not going to be enough. So I know that, so I just can't take those cases. And are some percentage of those cases going to get approved? Possibly, but I'm just not going to take it. So I just have to use my own gut after doing lots and lots of them, what's going to win.
And how many cases a year are you filing around right now?
I'm doing right now about 20 to 25 a month, which is a lot more than I used to. And I refer out probably, I'd say, I refer out of, for every one that I take, I refer 4 of them out to other lawyers. I have working relationships with other lawyers elsewhere in the country. And so I provide business leads to those other lawyers, and they take a certain percentage of the cases as well. So, I'd say in any 1 month, I may get 300-400 leads, something like that. I'll refer out, let's say it's 300 leads, I'll refer out 250 of them. And then I'll maybe 50 of them I'll contact and reach out. And of course, some people you can't get a hold of them for whatever reason. They just don't respond. But I'm just looking for ones I think that I can win, that I can make a difference. And if the person the other thing I think is if a person is applying for disability and they don't have a winning case, I'm going to tell them that. I think if this is not going to go your way, I wouldn't say don't waste your time, but, realize you're facing a real uphill battle. And so I'd rather somebody, hear that from me, I tell them the truth, as opposed to giving them false hope and saying, don't work for the next 3 years, hoping they're going to pay you when the odds are they're probably not going to.
Well, this has been a great discussion. I want to thank Jonathan Ginsberg of Ginsberg Law Office for joining us on this podcast, and to thank you for listening. You can find Jonathan at 4socialsecuritydisability.com. That was the number 4, socialsecuritydisability.com. And he has a Social Security Survival Kit at SSDanswers.com. That's SSD as in Social Security Disability Answers.com. You can visit me online at brickslaw.com. That's BRICKSLAW.com. You can also rate or review us wherever you get your podcasts, Apple Podcasts, Stitcher, Spotify, Google Play, or wherever. All of our contact information can be found in the link below. And for more details, you can personally email me at Peter, my first name, PETR, at brickslaw.com. Thank you.